Thank you, Mr. Chairman. Mr. Johnson, this is your first time to be fortunate enough to do this. Is that correct?
Yes, sir.
God bless you.
Thank you.
I hope you're still happy after you get done. When you get sued, explain to us how you go about defending those lawsuits. Who's your lawyer?
Of course. Our default lawyers are always the Office of Attorney General. That is our first request, is for them to represent us, except when in exceptional circumstances. Occasionally, as you may know, the Office of Attorney General declines to represent the Ethics Commission, in which case we hire outside private counsel. But to the first part of your question, when it comes to defending the laws under our jurisdiction, our view is that we are an administrative agency. We are there to administer the laws put under our jurisdiction by the legislature. We do not have the authority to unilaterally declare a law unconstitutional. The exception, of course, is if there's a prior judicial opinion directly on point. And I hate to assume, but I believe your question may be directed towards the recent Bruce v. Johnson litigation.
I have several questions towards that, but I'm not, anyway, but go ahead.
In that case, that fits the description that I mentioned earlier. There was a previous judicial opinion directly on point. And in fact, when the agency entered into a settlement agreement to not enforce the laws at issue in that case, the federal judge deciding the case wrote an opinion that indeed confirmed that the Ethics Commission had made the right decision to not amend that particular law.
Okay, in regard to that settlement, did y'all ask for the Attorney General's office to go out and solicit a settlement, or did they do that on their own and bring it to the commission?
Respectfully, Representative, that question would require me to reveal communications protected by the attorney-client privilege and or the deliberative process privilege. I have not been given the authority by my commissioners to do that, so I would encourage you to.
So you're telling me that's privileged, but as a named defendant and client, isn't that your privilege to waive that?
It is the commission's privilege to waive, and as I mentioned, the commissioners have not given me the authority to waive that privilege.
Have you asked for that authority?
Well, I've discussed the possibility. I have discussed it. I have not requested that authority. I have discussed with them what they would like me to do.
Would you request that authority, please?
Yes, sir.
Did the commissioners ever vote in open meetings to accept this settlement agreement?
I do not believe so.
Isn't that a violation of the Open Meetings Act?
Again, I don't believe so.
Explain to me why you don't believe so.
Well, again, that question, to some extent, if you are asking what the commission's position is, that question requires me to reveal communications protected by the attorney-client privilege.
No, I would disagree with you there. It's a simple question. Do you believe it violates the Open Meetings Act?
I will say that the decisions that the agency makes with respect to any litigation are informed by the advice that we are given by our counsel.
In reaching this settlement agreement, were you informed by the AG's office if you did not accept it, the AG's office would not further represent the commission in this matter?
Again, unfortunately, I have to decline to answer that because it would require me to reveal attorney-client privilege communication.
We have looked back, my staff has looked back and found minutes from prior years and prior settlements that were clearly voted on by the commissioners in an open and public meeting, and it concerns me very much that you or the commissioners have chosen not to do that, and I would suggest to you that it would be appropriate for the commission to vet this agreement and vote on it in an open meeting.
Understood.
How many uncollected fines and penalties does the commission have at this point?
That's a complicated question. It sounds like a simple question, but it is not. The process as it works is When the commission assesses a fine, it will send 3 notice letters notifying the filer of that fine. If the filer does not pay after a certain amount of time, the matter will be referred to the Office of Attorney General. That's the agency that has the authority to file a collection lawsuit, for example. And when things are referred to the Office of Attorney General, they will pursue collection efforts, but on occasion, or frankly with some regularity, they will close cases by determining that they are uncollectible. And so if you are asking, you know, it might be easier to talk about a particular year, 2022, for example.
Can you tell me how many fines have been referred to the Office of Attorney General and not collected? How many dollars are out there right now that y'all have referred to the OAG that have not been collected?
I do not have that information in front of me, Representative, but I, of course, can follow up.
I happen to have it in my office, and it's several $1 million
that is,
that the OAG has not collected over, and that doesn't include last year or this year.
I could confirm that.
Previous year, but it's several $1 million.
Yes, sir.
In fact, it was, the commission furnished me that information, and I appreciate that. You do have the ability to hire outside counsel, is that correct?
When approved by the Office of Attorney General, yes.
So if they choose not to represent you, at that point, you can hire outside counsel?
That's correct. They have a right of first refusal, as you might put it.
Can your commissioners go around that right of first refusal and choose to hire outside counsel?
That is a good question. That has not been the practice of the agency in the past.
I'm not worried about the practice. I'm worried about, can you do that?
It's an interesting question. There is a provision of law that says constitutionally created agencies can engage with attorneys without the Office of Attorney General's involvement. However, the budget bill prohibits any state agency, even if it is constitutionally created, from expending appropriations on private attorneys without approval from the Office of Attorney General. So
there's also a problem with having enough funds to go outside of the OAG and hire private counsel. Is that correct?
Oh, absolutely. That is correct. As a small agency, there's very little slack in our budget.
And so Bruce V. Johnson, the OAG, represented the agency.
Yes, sir.
And Salinas versus Johnson, the agency hired outside counsel. Is that because the OAG refused to represent, or the commissioners decided to hire outside counsel?
In that case, rather than request representation from the Office of Attorney General, the commission immediately requested the authorization to hire outside counsel, which the Attorney General provided. And the reason why is because that particular case implicated some of the same legal arguments and same legal issues that are still pending in other lawsuits that the agency is represented by outside counsel with. So for the purpose of ensuring a consistent representation, the commission's determination in that case was to request outside counsel.
And the Bruce V. Johnson, the agency did not request that. They just said, OAG, will you represent us? They said yes. They didn't have any interest in going to outside counsel. Is that correct?
I don't know that I would agree that they had no interest, but yes, that is a correct recitation of what happened. The commission did request representation from the Office of Attorney General, and the Office of Attorney General agreed to represent the agency.
The Violations of Open Meetings Act, it really does disturb me, and I don't understand. And I'd appreciate if you'd ask your commissioners why they refused to bring it to an open meetings, discuss it, and vote on it. And I plan on writing a letter to each of the commissioners asking that question, because it makes no sense to me. I served on the Water Development Board, and we went to executive session numerous times, but we never took an action in executive session. We always came out and did it in an open meeting, so the public had some idea what the agency was doing. And I think that the Ethics Commission of all of the agencies should be open, and their decisions should be made in a public meeting where the general public knows what you're doing, because that is your job. I mean, that is the commission's job, at least in my mind. I don't know how the rest of the members of this committee feel, but I do think that, given what you said in your opening comments, that's, you're responsible to the general public, as as well as the legislature and everybody, all the citizens of Texas, and to do it behind closed doors, to secretly to do something like that, I think it's just dereliction of duty. And I think you should point it out to the commissioners as your job. Guys, I think that we need to vote on this. And I think that is your job.
Understood, and I truly wish that I could talk more about this without revealing attorney-client privilege communications, and I will.
Well, I would ask you to go back and ask your commissioners if it's all right for you to waive that.
I will.
And it is the prerogative as the client for y'all to waive that attorney-client privilege.
That is correct.
I would appreciate it if you'd ask them, and we'll be writing a letter to the commissioners also asking them to waive that and to bring this out and vote on it publicly, discuss it and vote on it publicly.
Understood.
Thank you, sir, and I appreciate you being here today.
Thank you.